Okay, Mr. Jeff Collins, MLA, member for Fong Lim, and Assistant Minister for Primary Industry and Resources, and Assistant Minister for Police, Fire and Emergency Services. Dr. John Lowndes, Chief Judge of the local court. The Honourable Austin Asche AC QC, and Dr. Valerie Asche AM. Mr. Edward Santow, Australian Human Rights Commissioner. Professor Sue Carthew, Provost and Vice President of Charles Darwin University. Ms. Brenda Monahan, Commissioner for Public Interest Disclosures and Information Commissioner. Ms. Sally Sievers, Northern Territory Anti-Discrimination Commissioner. Mr. Michael Murray of the Australian Academy of Law. Distinguished guest, ladies and gentlemen, that concludes the proceedings. Good night. Welcome to the 7th Austin Asche Oration in Law and Governance. My name is Les McCrimmon, and I'm going to be introducing the speakers tonight. We are delighted to be back in Parliament House at this tremendous venue, and we very much thank the Honourable Kezia Pierik for allowing us to be here again this year. We have an excellent program for this year's oration in honor of the great Austin Asche AC QC, beginning with a welcome to country by Auntie Billawara Lee, CDU Larrakia Academic in Residence. After the welcome to country, the Provost and Vice President of Charles Darwin University, Professor Sue Carthew, will give a welcoming address on behalf of the university. Following that, Mr. Michael Murray will say a few words on behalf of the Australian Academy of Law, which is the co-sponsor of this event. And then we shall hear from Mr. Ed Santow, the Australian Human Rights Commissioner, and Mr. Santow, as your program indicates, will address the implications of Australia ratifying the optional protocol to the Convention Against Torture, and in particular, whether it provides us with an opportunity to make detention safe and humane, a topic, of course, of great relevance to us here in the Territory. Auntie Billawara Lee is an elder of the Larrakia Nation and is an internationally recognized author, healer, and teacher. She was appointed as CDU's first Larrakia academic in residence. I now call on Auntie Billawara Lee to welcome us to her country.
Bachi Gudalingua Darandara. Good afternoon, everyone. Thank you for the respect you show us, the traditional custodians of the land we stand on today. I'm very happy to welcome you all to the land of the Larrakia people, and I extend a special welcome to Edward, our orator today, and I pay my respects to dignitaries, friends and colleagues, and especially other elders present this afternoon. Did you realise that when you ask a traditional custodian to do a welcome, you are showing respect to the First Nation peoples of the land and their ancestors? And for me, a welcome to country is about acknowledging the past and looking to the future. Spiritually, I'm showing respect for my country and the custodians who are responsible for taking care of the land where we live. So what I'm doing is giving respect back to country and honouring the presence of my ancestors, whose ancient energy flows through all creation. Australian Aboriginal cultures are the oldest continuous cultures on Earth, and Australia is the only continent to have been occupied exclusively by hunter-gatherers until recent times. This history is not completely lost. It is retained in the minds and memory of successive generations of Aboriginal people, passed on through a rich oral tradition of song, dance, story and law. We are the traditional custodians of the land and waters of the Greater Darwin region, and although our lands extend up to 50 kilometres inland, we are known as saltwater people. Darwin was founded in 1869, but don't forget the history of this region goes back over 60,000 years. To us, this land here is our home, our supermarket, our pharmacy, our school and library, our entertainment centre and our spiritual centre. It is where we live, love, raise our families and eventually die and go back to our mother, the earth. Darwin has a very rich ancient history and the territory is one of the most beautiful destinations in the world. Well, that's my opinion anyhow. And Larrakia country is like a pearl with many layers of different peoples, of different cultures living and loving in this deeply spiritual place. We've always welcomed people onto our lands, just as I do so today. And we are gathered today on Dirrilla Dreaming, the Rainbow Serpent Dreaming site. It's one of our most important songlines, which runs around from where the convention centre is, across the coastline to Darwin, which we call Old Man Rock. He sits in the sea off the Casuarina coastline and is a very important sacred site as he keeps the Larrakia people strong and protected. He's very sensitive to changes to Larrakia lands and will make his feeling known if he is unhappy by sending big storms and cyclones. Several dreaming tracks travel into, out of and around Larrakia country and includes many areas of great cultural importance. We continue to have a strong spiritual, cultural and economic relationship with the land and the sea, and this is true for all the Aboriginal nations across this beautiful country. So it is on that note, it is my privilege on behalf of my elders past and present to welcome you all to Gwawa Daranyiki, our land. Welcome to my saltwater home of great food, friendly people, beautiful beaches and spectacular sunsets. And from the moment you arrived in Darwin or you were born here, you have been immersed in Larrakia ancestral energy. And as you walk across our land, I ask the ancestors to make your journey in my country a safe and nourishing one, and that they protect you while you are here. All that I ask in return is you walk softly on Mother Earth and treat her with love and respect as the Larrakia people do. So thank you. Mama.
Thank you very much for that, Auntie Billawara. Professor Sue Carthew was appointed Provost and Vice President of Charles Darwin University in 2016. Before taking up the position, Professor Carthew was the Pro-Vice Chancellor of the Faculty of Engineering, Health, Science and the Environment at CDU, and I now invite Professor Carthew to say a few words on behalf of CDU.
Many thanks, Les, and thanks very much, Billawara, for another fantastic welcome to country. Good evening, everybody. It's my very great pleasure to welcome you all here this evening. Pardon me, and to do so on behalf of the Vice-Chancellor, Professor Simon Maddox, who sends his apologies. He's in China just at the moment at the Confucius Institute board meeting, so wasn't able to make it. My pleasure at being with you this evening is tempered by contemplation of the gravitas of this year's Austin Asche Oration topic, making detention safe and humane. Can we grasp a once-in-a-generation opportunity? I would like to add my own welcome to our distinguished guests this evening and would just like to say a few words about the person after whom this annual address is named, a very great friend of the university. Austin Asche AC has played a very important role in the Northern Territory and has been a great champion of Charles Darwin University over many years. And I've seen that firsthand myself. Both he and Val have been a wonderful complement to the university over many years. Austin was appointed Chancellor of the Northern Territory University between 1989 and 1993. He was appointed as the 15th Administrator of the Northern Territory on the 1st of March 1993, and that was a position that he held until the 16th of February 1997. So he's been around a while. He was appointed a Knight of Grace of the Order of St John in 1993, and on Australia Day in 1994, he was appointed a Companion of the Order of Australia, or AC, for his service to the law, to tertiary education, and to the community, particularly to the people of the Northern Territory. In 2010, Austin was made Emeritus Chancellor of Charles Darwin University, and as such, he's something of a treasure to us at CDU and to the Northern Territory. So it's really wonderful that he's able to be the person after whom this annual address is named. So thank you so much, Austin, for your great contributions to us. I warmly welcome tonight's keynote speaker, Human Rights Commissioner at the Australian Human Rights Commission, Edward Santow, to the 7th Annual Austin Asche Oration, presented by Charles Darwin University and the Australian Academy of Law. And I also welcome Michael from the Academy. The topic of this year's Austin Asche Oration is very timely. Edward's presentation will address concepts of safety and humanity in the unfortunate, though at times necessary and lawful, process of detaining people, be it in prisons, youth detention centres, mental health facilities, or immigration detention centres. As Edward will tell us, in February this year, the Australian government announced it would ratify the optional protocol to the Convention Against Torture and other cruel, inhumane or degrading treatment or punishment. Thank you. OPCAT, as it's called, a measure to prevent the mistreatment of people in detention, was first adopted in 2002 as an international agreement and entered into in force from 2006. So it's great to see Australia ratifying it this year. As part of that ratification, the Australian government has pledged to establish greater oversight of Australian places of detention and improvement in conditions in those places. This will involve the establishment of a regime of independent inspections for all places of detention in Australia, so very pertinent to us in the Northern Territory. At CDU, at Charles Darwin University, we have a keen interest in matters surrounding the welfare of our fellow people. Indeed, it is within the bailiwick of most higher education institutions to contemplate rigorously, through a wide variety of disciplinary lenses, the plight of the human milieu. Our School of Law has a sustained record of inquiry into human rights-related issues, and this year alone has staged a number of seminars on related topics in conjunction with the Menzies School of Health Research. More broadly at Charles Darwin University, we have a collective beliefs statement that says, at CDU, we believe a new world university is one built on social justice, sustainability, creativity, and collective effort. We strive for excellence, integrity, accountability, and equal opportunity for all. At the current time, we look out on a world that appears particularly chaotic and perhaps intrinsically unfair in many ways. We hear at every turn about mistreatment of detainees or the terrible conditions detainees are subjected to. So we live in a time when very close scrutiny of the ethical and moral components of public policy are not only deserved but essential. So my hope for this evening is that Edward might shine a light on what positive steps have been taken and might be taken to address some of these issues. We hope that he might have some good news for us amid all the bad news that we seem to be bombarded with every day. So in closing, I thank you all sincerely for coming this evening and very much look forward to hearing from the Human Rights Commissioner, Edward Santow, shortly. Thank you so much.
Thank you, Professor Cartho. I now asked Mr. Michael Murray to address us in relation to the Australian Academy of Law. Mr. Murray is an insolvency lawyer at the Sydney offices of Ferrier Hodgson. More importantly for our purposes, however, he is a fellow of the Australian Academy of Law, and he is going to say a few words about that institution, which has been a co-sponsor of this oration almost since its inception. Mr. Murray.
Thank you, Les, and good evening all. As Les said, I'm based in Sydney, and that might explain my rather throaty voice, where the air is not nearly as clear as it is in Darwin, and I've come up with a heavy cold, but I hope you'll excuse that. I represent the Australian Academy of Law, whose president, Dr. Kevin Lindgren, has asked me to speak on his behalf here tonight. Kevin is involved in a very long arbitration in Perth, he tells me, and expresses his regrets about not being here, but has told me that it is always a very fruitful and very interesting event, and I look forward to the rest of the evening. The Academy of Law is very pleased to be co-hosting with Charles Darwin University this 7th Austin Asche Oration in honour of the service of Austin Asche, who I had the honour and pleasure of meeting only a short time ago, including his wife, Mrs. Austin. And I've note, as I was aware of before, but even more so having arrived in the Territory, the significance and the extent of Austin's contribution to the law and the community in the Northern Territory. Mr. Asche is also an eminent Fellow of the Academy of Law and represents to me the qualities to which the Academy aspires. Now, before coming to the detail of tonight's events, about which I will speak only very briefly, may I explain a little more about the Academy? It's a broadly based body comprising individuals of distinction in the discipline of law, from academia, the judiciary and the profession, who are committed to the advancement of that discipline and to justice according to law in Australia. It aims to promote a forum for cooperation, collaboration, constructive debate and exchange of views between those three sectors of the profession, all central to the maintenance of the rule of law in Australia. It was established in 2007 following discussions with the Council of Australian Law Deans, and this was followed by an Australian Law Reform Commission report, ALRC 89 for those interested, called Managing Justice, a review of the federal justice system, which recommended the establishment of the Academy. The Academy is therefore now in its 10th year, and it comprises 35 Foundation Fellows, over 300 Fellows and Life Fellows and Overseas Fellows. In the Northern Territory, its Fellows include the Chief Justice of the Supreme Court, the Honourable Michael Grant, Chief Judge Dr John Lowndes, who I have met here tonight, of course Professor Les McCrimmon, and of course the Honourable Austin Asche, including of course other members of the bar, the legal profession and the legal community in the Northern Territory. In the context of this evening, I might just mention one of our honoured fellows is Emeritus Professor Rosalind Croucher, formerly the chair of the Australian Law Reform Commission and, as of recently, the president of the Human Rights Commission. Perhaps I could best explain the Academy just very briefly in putting tonight's talk in context by explaining some of the recent events the Academy has organised in its various locations in the capital cities around the country. We recently co-hosted a two-day conference on the future of Australian legal education, which was co-hosted with the Australian Law Journal and Thomson Reuters as the publisher of that journal. And it was a two-day conference in August. And certainly Professor Les McCrimmon and many others distinguished in legal education attended. Another conference recently, or a session, was from Professor Erika Tichara of the University of Western Australia's Oceans Institute, who spoke on bringing science, technology and the law together to solve the illegal fishing challenge in Perth. As joint supporter with the University of Tasmania, the Academy sponsored an event called Does Our Justice System Work? Perspectives from the Bench, with panellists comprising one of our very honoured, of course, fellows, the former Chief Justice, the Honourable Robert French, a former Federal Court Judge, the Honourable Peter Heery, the Honourable Chief Justice of Tasmania, Alan Blow, and the Chief Magistrate, Catherine Geeson, all in Hobart. The annual Patrons Address this year, which we have every year, with very distinguished guests speaking, will be given by one of our overseas fellows, Professor James Crawford, a judge of the International Court of Justice, which is being held in Sydney this month. In October in Melbourne, the Honourable Justice Michelle Gordon of the High Court of Australia will speak on what I find an intriguing titled topic, Corporations and Corporate Insolvency Jurisdiction of the Federal Court, from Passerby to Chameleon Lodger. And then finally, just one, not finally, but certainly by no means least, Mr. Robert French will speak on the topic of rationality and reason in administrative law, Would a roll of the dice be just as good? Question mark. I'm very intrigued. If I could get to Perth, I'd love to hear that speech. I might just mention I was involved myself in organising some events in Sydney, and the theme of the Academy's events maybe is typified by what we did hold in Sydney, which was a series of debates with eminent members of the profession and outside the profession, asking questions about, one of these questions often asked, is law a profession or is it a business nowadays? I think we've all heard that question asked. What are the limits of the law? In other words, how far can the law go in terms of people's expectations of what it can do? Often an issue in consumer protection. And also, what makes a good lawyer? And I'm just thinking here tonight, there was a legal education conference recently, and we had a very distinguished overseas guest, Professor Martha Nussbaum from the University of Chicago, who spoke of the merits of lawyers studying not only law, but more broadly based humanities subjects along with law to make themselves more complete lawyers, something that I myself very much favour. And I just think myself, in terms of our following guest's topic, that human rights is probably a well-founded subject in many law schools, but I'm not sure that it might receive the priority overall that it should do in legal education. As to tonight, the Academy is very pleased and honoured to be able to co-host Mr. Edward Santow to speak on the proposed ratification of the optional protocol to the Convention Against Torture. I myself have no qualifications to speak in any detail on his topic, save as a citizen and as a lawyer, and in particular from my very useful and interesting discussions with Edward in the last few days and my own research into the topic before coming here tonight. I very much look forward to this session as representing a supreme example of what the Academy of Law is about. And I thank you for CDU for co-hosting with the Academy this event. Thank you very much.
The main event. The Austin Asche Oration in Law and Governance will now be delivered by the Australian Human Rights Commissioner, Mr. Edward Santow. This is a bit personal for me because this is the first time in the 7 years of the oration that a former student of mine is going to be giving the oration, which frankly just makes me feel old. I've had the pleasure of knowing Edward since his days at the University of Sydney, and even in those formative years, Ed was very committed to social justice. And he accompanied me on 2 occasions, once as a student and once as a senior lecturer at the University of New South Wales, to the Global Alliance for Justice Education Conference. And after seeing what that group did as a student, this is in 2001, Edward joined the International Steering Committee of that conference. Ed is one that makes sure that he joins things, and we had the Honourable Justice Michael Kirby, or former Justice Michael Kirby, here about a month ago, and he said to the next generation, to make a difference, you must join things, and no one typifies that better than Edward Santow. After a short career at Mallison's, he was enticed to leave that lucrative career behind and become a legal officer at the Australian Law Reform Commission. And after that, he went on to be, again, a senior lecturer at the University of New South Wales. From there, he took over as the CEO of the Public Interest Advocacy Centre, which is located in Sydney but does public interest litigation throughout Australia. And in 2016, he was appointed as the Australian Human Rights Commission. All this was still in his 30s. And that prompted the World Economic Forum to include Edward in its 2017 class of young global leaders. It gives me great pleasure to invite Edward Santow to deliver the 7th Austin Asche Oration in Law and Governance.
Thank you very much, Les. I'm going to have more to say about you in a moment. Thank you also, Michael. I'd particularly like to acknowledge the Aboriginal owners of the land on which we are meeting today, the Larrakia people. The welcome to country was beautiful. It was also, for me, particularly poignant given the subject of my oration tonight, knowing that so many more Aboriginal people are detained in Australia than non-Aboriginal people. I'd like to pay tribute to the Honourable Austin Asche and Dr. Valerie Asche. A problem in delivering an oration in somebody else's honour is that sometimes you wrongly become the focus. And I'm so grateful to Professor Carthew, not only for being a co-host, but also for introducing us to Austin Asche's incredible history and contribution. I'd like to acknowledge the fact that there are many prominent Territorians and Australians here, and also say that you're all very special. But before I go any further, I must say a few words about Professor Les McCrimmon. Les has been a mentor and role model for me for the best part of 2 decades. And so it is somewhat disconcerting that he referred to me at the start as Mr. Santow. Before Les became a lawyer, he was a human. There's nothing unusual about that. All lawyers were once human. But the thing about Les is, and I mean this in the most sincere way, is that he has retained his humanity much more than he is a lawyer, fine lawyer though he is. He is unquestionably one of the most humane, one of the most generous people that I've ever encountered. He is a natural teacher, and he is also someone who is deeply allergic to bullshit. That extraordinary combination of qualities makes it an honour, an extraordinary honour, an honour that ironically almost leaves me speechless to be asked by Les to give this speech. So, reflecting on the current state of US politics, the American writer Rebecca Solnit dreamed up something she called the compliant compass. A wonderful device that agrees that north is wherever you want it to be. This means that you can be lost in the middle of the jungle, worrying about the crocodiles snapping at your heels and how you will survive. But then you remember your trusty compliant compass. You whip it out and you're relieved to see that home is straight ahead. The best part is that it doesn't matter which direction you walk, you're always right. As someone with a poor sense of direction, and unfortunately someone who's also really bad with maps, this would be very reassuring. You can stride on confidently knowing that in 2 shakes you'll be sitting in your easy chair with a nice refreshing drink. Of course, there's also a downside. Eventually, the happy delusion is shattered and you have to confront that you're lost. To make matters worse, with all the frolicking that you've been having with your compliant compass, it's now dark and the crocs are looking really peckish. We all know intuitively that there's real danger in someone telling you everything's fine, you're 100% okay, if in reality you're not. As annoying and dispiriting as it is in the moment, it's far better to know that north is the opposite direction to where we thought it was when we set out for our morning stroll. It's better to know that we're a long way from home and that it'll be hard work to get back. It's better to know these things because that knowledge is a precondition to formulating a realistic plan to get us on the right path. I don't think anyone has ever mistaken the Australian Human Rights Commission for a compliant compass. Our role is to be an independent, authoritative voice on how international human rights law applies to Australia and how to improve the protection and promotion of human rights in this country. Our independence doesn't mean that we're in constant disagreement with the government. In reality, we agree on many of our greatest human rights challenges. For example, the need to address historic and ongoing inequality experienced by Aboriginal and Torres Strait Islander people, the importance of protecting the basic rights of especially vulnerable groups such as children, and the need to strike an appropriate balance between human rights that sometimes come into conflict. But disagreement between us and the government is most likely to occur on how best to address these issues. There's a risk in overemphasising that disagreement because it can blind us to the very real opportunities to work cooperatively and to find practical compromise that allows incremental but real improvement in protecting human rights. I say all of this by way of introducing the subject, a little bit obliquely, of my Austin Asche Oration, which is about making detention safe and humane. Here in Darwin, I know that you know a lot about this subject already. In November, the Royal Commission into the Protection and Detention of Children in the Northern Territory is due to deliver its findings and make recommendations about how to improve the system. Given the evidence that the Royal Commission has already heard, it seems likely that we will be shocked anew. Some of the statistics revealed in the Royal Commission's interim report are quite rightly a source of outrage and shame. That the Territory has the country's highest rate of children and young people in detention, as well as engaged with child protection services. That 94% of children in the Territory's detention system are Aboriginal. That 89% of children in out-of-home care here are Aboriginal. And that some of these statistics are getting worse, not better. We also know that statistics can be cold and clinical, and that behind the numbers are real people. In some ways, Dylan Voller has become the public face of young people who are detained, especially here in the Territory. While I don't want to add to the inordinate public commentary on his particular situation, I do think it's useful and important that we look at specific individuals, that we hear from them directly, and that we treat them with dignity and respect. I want to pause briefly to make some comments about what I mean by that. There are three things in particular. First, there's a danger in setting policy in reaction to extreme cases that are not representative of a broader phenomenon. While statistics might be cold and clinical, they do help us understand the scope of problems. Our policy responses should be different if we're responding to an isolated case of mistreatment rather than a systemic problem, and we must be able to differentiate between the two. However, what is really clear, just from the interim report alone, is that Dylan Voller's situation is not an isolated one. Secondly, in considering the experiences of individuals, especially young people and people who are in other ways vulnerable, there's a risk that we inadvertently look at them as specimens in a zoo. The attention of public figures and of the national media has a real and potentially massive impact on these people. That impact can and often is negative, particularly if the individual doesn't have adequate support and assistance in dealing with the harsh glare of public spotlight. And thirdly, we need to confront something which is sometimes difficult to confront, and that is that human rights are not about vindicating the rights of heroes. Too often, especially when we discuss human rights issues, we try to force individuals into some kind of caricatured role as either a saint or a sinner. If a child's basic human rights are violated, it should be completely irrelevant whether the child is rich or poor, a good student or a lazy one, or whether the child has a history of encounters with the police. As an advocate for human rights, I know that emphasising the positive qualities of a child whose rights were violated plays on our heartstrings. I get that. It heightens our sense of injustice. But we can't lose sight of an important principle. Human rights don't apply only to angels, and our rights are not contingent on us behaving angelically. So turning more specifically to Australia's detention system, how should we characterise it? Well, we should start by understanding how people end up in detention in the first place. In other words, whom do we lock up? Why do we lock them up? And for how long? There's a growing understanding that many of our policies at the front end of the justice system cause over-incarceration. That is, we're locking too many people up, especially for relatively minor offences. Those people are then detained for too long, and it means we miss opportunities to rehabilitate them and put them on a better path. Moreover, the correlation between high rates of detention and high levels of socio-economic disadvantage cannot be ignored. The policy settings in Australia that produce these results have been heavily influenced by a number of countries, but none more so than the United States. The interesting thing is that over the last 5 to 10 years, US policymakers are starting to rethink. Intriguingly, some of the strongest push for change in prison reform isn't coming from the political left or progressives. For example, conservative voices like Newt Gingrich have taken the lead in identifying the counterproductive impact of high incarceration and are pushing to reverse the ever-increasing growth in the prison population. If we understand better what causes people to be sucked into the criminal justice vortex, and we seek to address those causes, we're much more likely to protect the basic human rights of the people involved, but also to build a safer and more harmonious community. We can see the first green shoots of change here in Australia. For example, the increasing application of justice reinvestment strategies have an explicit goal of reducing the number of people in detention. Logically, changes like this will help us reduce the number of people we detained. But I'm also realistic enough to accept that there's a strong, abiding consensus that relatively large numbers of people will still be detained in Australia, in places as diverse as prisons, youth detention centres, mental health facilities, immigration detention, even aged care facilities and elsewhere. So that means we must turn our attention also to how we as a community treat people when they are detained. In my view, problems in how we treat detainees in Australia are rarely the result of a deliberate policy to do systemic harm. Instead, those problems tend to arise from policies and practices that, to try and use a compendious term, are simply inadequate. What do I mean by that? They're inadequate in the sense that they don't do enough to protect the basic rights of people in detention. Too often, this allows small problems to be left unaddressed and then to fester. To give some concrete examples, too often we have inadequate protections of the most vulnerable detainees, or we have insufficient safeguards to protect against and then correct mistreatment by detention centre staff, or we have practices that needlessly put detainees at risk. Let me give an example. As Les mentioned, before coming to the Commission, I worked at the Public Interest Advocacy Centre, and that had a particular focus on people with disability and people in detention. Some of the cases that we worked on at PIAC still haunt me. One involved a young man, and I'll call him John, who had a psychiatric condition that became manifest in adolescence. John committed a number of minor offences. His most violent crime was robbing a service station worker of a packet of cigarettes. He was armed at the time with an ice cream. John entered prison with a clear diagnosis and treatment plan. The prison authorities didn't dispute the diagnosis, but they insisted on undertaking their own medical assessment. John waited. Days passed, then a week, then more days passed, and still no medical assessment was completed, and therefore no treatment was given to John. Eventually, after well over a week, the inevitable happened. John had a psychotic episode and threw himself off a ledge. He sustained horrific injuries. John will never be able to walk properly again. He'll certainly never be able to work. He'll live in constant pain for the rest of his life. His mum, who he worked really closely with in the case, also lives with the constant fear that and knowledge that she won't always be around to help John in the way that only a parent can. In prison, John should have been safe. And part of my point is that no one deliberately set out to hurt him. It was something different. It was something more insidious and subtle in the failures of policy and practice that contributed to his being harmed. The urgency of his medical assessment or of his receiving medication was never considered when John was being absorbed into the rest of the prison population. We're daily assaulted with bad stories about what happens in places of detention in Australia. But taking Professor Carthew's challenge, I'm here also to offer some hope. The hopeful part of the story starts with the federal government's decision to ratify and implement a treaty known as the Optional Protocol to the Convention Against Torture. Everything in the UN has to have an acronym. Its acronym is OPCAT. Lends itself to a lot of puns, and I promise you I will not subject you to any of them. The government is committed to take the key legal step of ratification by December this year. Now, OPCAT is a really unusual treaty. Most human rights treaties set out to create specific legal rules. They tell you what are people's rights and what are people's obligations. OPCAT doesn't do that at all. It creates no new substantive rights. Yet it could be the single most positive development in a generation in improving conditions in all Australian places of detention. What this treaty will do is to enhance how independent bodies inspect places of detention in Australia. The idea is that we already have clearly set out in international human rights treaties what detention authorities are meant to do. What we need is better accountability and better, frankly, assistance to those detention authorities and the governments that sit behind them to make sure that good practices are being applied and that people are protected and not harmed in detention. And so what should happen, if other countries are any guide, is that we will be able to identify and address the problems of detention before they escalate into serious mistreatment, torture, and so on. In other words, what OPCAT is designed to do is to take a preventive approach. Through regular and unannounced visits, the problems in places of detention will be more rigorously identified. And then, through an ongoing and consultative dialogue with those in charge of detention facilities, those problems should be addressed. So under OPCAT, Australia will be required to establish what's known as a National Preventive Mechanism, or NPM. Essentially what this will be is a network of independent Australian monitoring bodies that proactively go into places of detention to identify practices that could be in breach of human rights and then work with federal, state and territory governments to fix them. Now, I know that there are already bodies that go into some detention facilities in Australia. The difference is that this will resource those bodies properly, or this should resource those bodies properly in a way that they were never resourced properly before. It will also give them access to a body of knowledge that they've never had, so that when they go into a detention facility, they see a terrible practice that could violate human rights. They can then say, A, this practice is incredibly harmful, but B, we can give you half a dozen alternative practices and policies that will better protect the basic rights of the people detained here. The other element of OPCAT is that the UN will also be able to send a monitoring team to Australia, most likely once every 8 to 10 years, to inspect a small selection of detention facilities. We shouldn't be under any illusions about the scope of detention problems in Australia. Countless reports say we need to improve conditions of detention. Horrifying images, such as those broadcast last year from the Dondale Youth Detention Centre, beamed from here in the Territory, not just to the rest of Australia, but worldwide. They show why we must act and why we must act now. I think it's important, though, to acknowledge that places of detention are challenging environments. They're places of punishment and deterrence, but also of rehabilitation. There's clearly an enormous tension between those different aims, and that can make it more difficult for human rights to be protected. The power imbalance between those detained and those responsible for detention increases the risk that detainees' human rights will be breached. That's particularly true when we consider the risk of mistreatment and torture. To give an example, persons with disability are especially at risk. Prisons tend to exacerbate poor health conditions and reinforce pre-existing disabilities. Initial screenings may overlook disabilities, and staff may not be adequately trained in responding to people with disability when they arrive in detention. And in that sort of environment, problems abound. For example, to give practical examples of what we actually see, people with disability being moved around detention systems, including in and out of prisons, with no holistic or frankly adequate approach to their needs. Inadequate mental health services to meet the needs of people with disability. Physical and chemical restraints being used disproportionately and for longer periods of time on detainees with cognitive disabilities as a form of behaviour management. People with cognitive disabilities disproportionately being held in solitary confinement, thereby making their conditions worse. And people with physical disabilities lacking access to the special equipment that they need to have what is a basic human right to things like education and recreation. At a time where fully half of all people imprisoned in Australia have some form of psychosocial, cognitive or physical disability, these sorts of problems show just where the most pressing and worst breaches of human rights are occurring. By ratifying OPCAT, Australia can also draw on the experiences of other countries to develop our own inspection regime to meet the needs of people with disability. Australia is not exactly an early adopter, but what that means is that we can look to that international experience. And let me give you a few examples. The Serbian inspector conducts joint visits to places of detention with the support and expertise of NGOs from the disability sector. And it develops disability-specific capacity building programs that have already shown, just in the first few years, enormous success. In France, the independent inspector raised awareness of the high risk of abuse in psychiatric institutions, and that led to better conditions, measurably better conditions, and changes to legislation in how people in those institutions were isolated and restrained. In Georgia, a country where there have been huge problems with detention, the inspector conducted thematic monitoring, focusing 1 year on the situation of persons with disability. The findings and recommendations led to the government changing correctional policy to better cater to the needs of persons with a disability and to ensure appropriate training was given to the staff in the prisons. And then closer to home in New Zealand, the inspector permitted the inspection of psychiatric facilities which had never previously been covered under any inspection regime. The New Zealand inspector is currently focusing on the use of seclusion and restraint across the detention environment. And those are practices that can have a serious negative effect on detainees' mental health. When he announced that Australia would ratify and implement OPCAT, the Attorney-General George Brandis also asked the Human Rights Commission to consult with people that have experience. That's people who have direct lived experience in detention, but also especially people from civil society, with a view to the Commission advising the government how to make OPCAT work in a really practical, constructive way. The establishment of Australia's inspection regime over the coming years will require careful planning to ensure that the mechanism is robust and is best able to meet the goals of preventing ill treatment for those held in places of detention. It's likely that the government will adapt and enhance the work of existing inspection bodies, as I've mentioned before, with at least one inspection body in each state and territory. But in this design phase, it's vital that input and consultations occur with the broader community to determine what people want and need. We at the Commission have just finished the first phase of our consultation, and this month we mark the start of the second stage as we speak with people around Australia about the problems in detention and how to address them. And I'd like to acknowledge two people in this room that are helping me do that, Sally Sievers from the NT Anti-Discrimination Commission, and I'd also like to pay tribute to my colleague Sophie Farthing, who's leading this work with me at the Human Rights Commission. OPCAT has the potential to be a pragmatic and practical method of addressing many of the issues facing people with disability in detention. We must use this as an opportunity to build on good culture and good practices that already exist throughout Australia's detention system. The best protection of human rights, especially in an environment like a prison, is preventative. And that means having a strong culture of respect and care for detainees. And thirdly, we need civil society and the community more generally to work constructively with federal, state and territory governments to identify both problems and solutions, and then strongly to hold those detention authorities to account. Perhaps I can start to wrap up by referring to another case from my time at PAC that still haunts me. Our client there was a young woman, I'll give you her real name, Joanne Darcy. Joanne's case was a really interesting one. She had also been charged with a series of minor offences like stealing a bicycle. She happened to have a cognitive disability, and by reason of her cognitive or intellectual disability, when her case came to trial, there was no dispute that she had actually done the things that she was accused of. But the court quite rightly said, well, this person shouldn't be convicted. It was largely a function of her intellectual disability that she committed these acts. And so quite rightly, no conviction was registered and she was not sent to prison. Instead, what the court did, again, completely understandably, was it said Joanne should have a psychological assessment to determine how best to care for her and accommodate her. She was sent to a forensic facility, which for all intents and purposes looks and feels like a prison. I remind you, she was sent there for psychological assessment. She was then detained there for 5.5 years. Not days, years. purportedly for a psychological assessment. Joanne's case is one of the cases that really does haunt me because we lost that case. There was no breach of Australian law, at least that's what the courts decided. They may or may not have been right. And notwithstanding that you had some very well-meaning people within both the court system and in the government care and protection system saying very loudly that Joanne should be released, she was not, at least not until later when we became involved. Joanne's story reminds me of how a system run by humane and well-meaning people can nevertheless produce grave injustice. The former US Supreme Court Justice William O. Douglas emphasised the importance of vigilance to halt the sort of activity that can slide imperceptibly ever downward. He said, and I quote, "As nightfall does not come at once, neither does oppression. In both instances, there's a twilight when everything remains seemingly unchanged. It's in such twilight that we all must be most aware of change in the air, however slight, lest we become unwitting victims of the darkness." End quote. When a person is detained in prison, a mental health facility, anywhere, they remain human. Protecting their basic dignity is just as important as it was before they were detained. We should do it because it's right. But protecting a detainee's basic rights is also in all of our interests. If a person is brutalised in detention, they'll be more dangerous on their release. By contrast, treating detainees humanely comes with no downside. Instead, it presents an opportunity for education, reform, and healing. Dostoevsky said that a community's degree of civilization can be judged by entering its prisons, and that's certainly true. But it isn't enough just to go inside. We have to get our hands dirty. We have to work within the system to make sure that we live up to the standards we've set for ourselves. Ratifying OPCAT presents an opportunity to make sure that people who are detained in Australia have their basic rights respected. We need to work constructively with government to seize that opportunity. And I look forward to working with many of you to do just that.